이번 세션은 인공지능 시대의 특허법상 도전들이라는 주제입니다. 오전 기조연설에서 마르코 알레만 와이퍼 사무차장보님이 언급하신 다보스 사건들을 포함하여
So this session is on the challenges of the era of AI, along with Davos case that Marco Aleman, WIPO Assistant Director General mentioned. We will explore various issues related to patent and AI. So please welcome Woo Sung-yeop, Judge of High Court. And Lee Hae-jin, also Judge of High Court, and Kim Kwang-nam, Judge.
네, 안녕하세요. 저는 방금 소개받은 대한민국 특허법원의 우성엽 판사입니다.
Thank you for the introduction. I am Woo Sung-yeop,
먼저 이번
the
세션에서 발표하실
High Court Judge at Patent Court of Korea.
성의 알파벳 순서에 따라
So,
소개해드리겠습니다.
in the alphabetical order, I would like to introduce panelists for this session. Please refer the booklet for their detailed bio. Please give them a big round of applause.
먼저 미국 연방 순회 항소법원의 페더럴
It's
서킷
Raymond
저지
T. Chen, Judge of the United States Court of Appeals for the Federal Circuit.
판사님은 비디오 영상으로 참석을
He
해주셨습니다.
sent his pre-recorded presentation.
두 번째 한국 특허법원에 근무하시는 이혜진
Second is Hae-jin Lee, the High Court Judge of Patent Court of
세
Korea.
번째로는 한국의 전
Third,
특허법원 판사이자 현재 대구지방법원에 근무하시는
It's Kwang-nam Kim, previous judge at the Patent Court and the Daegu District Court of Korea. And fourth is Mark Lemley, professor at Stanford Law School.
다섯 번째는 영국
Fifth,
잉글랜드 웨일즈 고등법원
Richard Mead, a judge in charge of intellectual property in the High Court of England and Wales.
여섯 번째로는 중국
Sixth,
샹하이
we have Judge Hu
지적재산권법원의
Ami
판사님입니다.
from Shanghai High People's Court in China.
일곱 번째는 호주
Seventh,
연방법원 판사로
we have Judge
근무하시는
Nai Peram from the Federal Court of Australia.
여덟 번째는
And
일본
eighth,
지적재산 고등재판소의
we have presiding Judge
부장판사로
Tamotsu
근무하시는
Shoji from Intellectual Property High Court of Japan.
쇼주 판사님도 비디오로 참석해
Judge
주십니다.
Shoji also sent his pre-recorded presentation.
이처럼 각국의 저명하신
As
판사님들과
such,
교수님을 패널로 모시고
it's an honor to have honorable judges and professors from around the world.
이번 세션에 참석하시는 외국 발표자들 중 미국과 일본의 패널 분들은
The Japanese and the American panelists have sent pre-recorded video clips, and all other panelists are here with us real-time virtually.
이번 세션에 참여해 주신
Despite your busy schedules, thank you for joining this conference. And it's 5:20 in the morning in the UK, so special thanks goes out to Judge Richard Mead.
이번 세션에서는 인공지능
This
시대의
session, we will look at the
도전이라는 주제에 대해서
challenges to the Patent Act in the era of artificial intelligence, and I look forward to hearing insights from the panelists. Especially, we will first look at the patent eligibility of AI programs and the patentability of AI-related inventions and Patent Act-related issues that has to do with AI inventions, and fourth, about the infringement by AI.
이번 세션의 주제에 대해서 발표자들께서
So, since we have received detailed responses from all the panelists, which are in the reference book, please refer to that.
이번 세션은
We have many panelists for this session,
발표자들께
as well as many topics, so I apologize in advance for not allotting enough time.
발표자들께서 주어진 시간 내에 답변을 맞춰
So
주시면
please make your answers within the allotted time. And I have one more announcement.
이번 세션에 참여하신 분들을 대상으로
To all the participants in the seminar,
인공지능 시대에 인공지능을 과연
whether
통상의 기술자로 볼 수 있는지
the AI can be viewed as a person who has ordinary skills in the art, POSITA, and whether we need to amend the Patent Act to give the status of inventor to the AI. This is asked through a survey, so please, if you receive the text, please answer the survey.
예, 시간 관계상 이제 바로
Given the time constraint, let's jump into the topic.
인공지능 프로그램 발명의 일반적인 개념과
So
내용은
the general concept of AI generated invention is as what you can see in the slide. Please refer to that.
예, 이어서 첫 번째 및 두 번째 소주제와 관련된
Let's look at the first and
인공지능
second
로봇 청소기
subtopics.
시스템의 사례를
It's the AI
설명드리겠습니다.
robot cleaner
청구
system
범위는
case.
보시는
The
슬라이드에 기재된
claim
내용을 참고해
is
주십시오.
on the left side of the
이 청소기 시스템은
booklet, and
A
this
학습
robot
데이터를
cleaner
B
system,
알고리즘으로 지도
this
학습된
is where the learning data A is learned with
영상 인식
algorithm
모델을
B.
포함하고 있다는
So
점에 특징이 있습니다.
video recognition model is included in
예,
this
그럼 첫
system.
번째 주제를 시작하겠습니다.
We will
첫
now
번째
begin
주제는
with the
인공지능
first
프로그램
question.
발명의 특허 대상 적격에
It
관한
is about
것입니다.
the patent eligibility of AI
예,
program
공통질문 1과 2를
inventions.
같이 진행하겠습니다.
Common questions 1 and 2 will be asked
먼저
together.
각국 패널분들께
So
인공지능 프로그램 발명의 특허
please
적격성과
inform us of
관련하여
the examination
각국의
criteria or
심사 기준이나
determination
판단
criteria
기준
for
등에
patent
관한
eligibility of AI
부탁드리겠습니다.
program inventions in your country.
또한 프로그램 자체를 물건의
Second,
발명으로 보아 특허 등록 대상으로
please
인정하고
let us
있는지,
know if the program itself is a patentable subject matter, or whether it has to be equipped within a storage device in order to be eligible.
답변은 1분 30초 이내로
Please
해주시면
limit your
감사하겠습니다.
answers to 1 minute and 30 seconds.
예, 패널분들의 답변 순서는 국가의 알파벳 순서에 따라서
So
진행하도록 하겠습니다.
the alphabetical order of the country's name will be followed for the responses. First, we will hear from Judge Humi from China. Thank you.
헬로 후미 판사님.
Hello.
Professor Humi?
Hey, yes, I'm here. Hello.
예,
Hello,
답변을
everyone.
부탁드립니다.
Your answer, please.
In China, for the common question 1, in China, the Patent Office of National Intellectual Property Administration (PRC), hereinafter CNIPA, accepts, examines, and approves patent applications and authorized patents. According to the patent law of the PRC, the inventions as used in this law means inventions, utility models, and designs. According to the guidelines for patent examination, there are no examination or determination criteria specifically for AI program inventions, but examination criteria for inventions involving computer programs can be for reference. Since authorizing patents is a duty of the CNIPA, the judge in China will not re-examine the eligibility of the patent generally. For common question 2, according to the patent law of the PRC Article 25, rulers and methods for mental activities should not be granted patent right. According to the guidelines for patent examination, the invention patent application involving the computer program, which is a part of technical solution, is the object of patent protect. The purpose of executing the computer program to solve technical problems, to control or handle external or internal objects by technological means of running the program on computer, and thus get technical effect in accord with nature, makes the computer program patentable. Therefore, in China, the AI program itself is not eligible for patent registration if the program can't be combined with specific technical solution. Thank you.
예, 답변 감사합니다.
Thank you very much for that answer.
한국에서는
So in the case of China, with regards to program inventions, if they cannot be combined with devices, they are not patent eligible. So next, moving on to Japan, Professor Tamuchi will hear his video message.
Patent eligibility of AI program inventions. Common question 2. In Japan, a program itself is concluded in the definition of the product invention. Patent Act, Article 2, Paragraph 3, Subparagraph 1. As for a patentable subject matter, the program itself can be patent eligible if a claimed invention recites the creation of a technical idea utilizing the law of nature. Patent Act, Article 2, Paragraph 1. According to the examination guidelines for patent and utility model of Japan Patent Office or JPO, the creation of a technical idea utilizing the law of nature can be established by proving that information processing by the software is concretely realized by using hardware resources. Also, in accordance with Article 2, Paragraph 4 of the Patent Act, not only a computer program itself, but also any other information equivalent to a computer program can be patent eligible.
예, 일본 조지 판사님 답변.
Yes, thank you very much for that
예,
answer.
아시다시피 일본은
As you are well aware, in the case of Japan, in the patent law, the program itself is recognized as invention of an object. The next we'll move on to Korea. In Korea, Article 2, Paragraph 1, the Patent Act provides that the term invention means the highly advanced creation of a technical idea utilizing the laws of nature. However, the Patent Act does not prescribe a program itself as a product invention. The Korean Intellectual Property Office provides patent examination guidelines that show the patent eligibility for an AI invention as follows, where the specific software in an AI-related invention performs data processing using hardware. The following constitute the creation of a technical data utilizing the laws of nature. The data processing device that operates in cooperation with software, the operating method itself. However, a computer program itself is only a set of orders stored to operate a computer, and thus is not a creation of a technical idea utilizing the laws of nature and cannot be deemed as an invention in Korea. An AI program itself is not patent eligible, but an AI program stored in a computer readable medium is. So far, no precedent presents how to treat AI program inventions in Korea. As you can see from the slide, the number of patent applications in Korea related to AI is increasing sharply. Thus, we expect that the market is going to expand at a rapid pace going forward in this area. Thus, we can expect that there will be a case where patent eligibility standard for AI-generated inventions is determined. Thank you very much. Thank you for the answer. Next, from UK, Judge Richard Mead will hear your answer.
Good morning, Mr. Chairman. Thank you very much for your kind invitation. In the UK, this law is governed by an international treaty, the European Patent Convention, which is applied uniformly in the states that are signatories to the EPC, and the eligibility for patentability of computer programs is dealt with by Article 52 of the European Patent Convention, and this provides that a computer program as such is not patentable, but a computer program may be patentable if it is claimed in a form which gives rise to a technical effect. In particular, a technical effect can reside in controlling a real physical system, or indeed in controlling the physical operation of the computer itself. But the computer program on its own is not patentable, and nor is it an adequate technical effect that the computer program runs, for example, faster. There's been quite a lot of law in the European Patent Office about this, and in my document, which is in the handbook, there are quite a lot of examples given of situations where computer programs have been held to generate a technical effect, and therefore the overall effect is that with a proper claim form, AI can be embodied in an invention. Thank you.
네, 답변 감사드리겠습니다. 예, 들으셨다시피 영국이나
As you have heard,
원칙적으로 프로그램 자체는
in principle, in UK,
테크니컬 이펙트, 그러니까 기술적 효과가
they're not deemed as a patent eligibility, but if there is significant technical effect, they can be deemed as patentable.
미국 패널 분들의 비디오 답변은
And now, the video message from the US speakers encompasses the common questions 1 as well 2. So in the second topic, we will be showing the video. So
그러면 첫 번째 질문을 마치고 두 번째
and now move on to the second question.
넘어가겠습니다. 이번 질문은
Moving on.
이번 질문은 인공지능 관련
This question is about whether the learning data or learning data structures or algorithms have patent eligibility. So please explain whether your country has precedents or some academic discussions regarding this topic, and please limit your answer to 1 minute and 30 seconds. First, we will hear from Judge Humi from China.
In China, if a claim is essentially to protect the computing and operation of the data, but application did not reflect that the algorithm can be used to solve specific technical problems in some technical field, the claim can't be regarded as patented technology by which can solve specific technical problems and get technical effect in accord with nature. That's to say, whether or not the data or algorithm have the patent eligibility depends on if they can be used to solve a specific technical problem or not. Up to now, that and the algorithm by itself are not eligible for patent registration. Thank you.
예, 답변 감사합니다.
Thank you for your answer. Judge Humi mentioned that algorithm and data itself has no patent eligibility, but it has to be seen whether it has effect of solving specific technical problems.
다음으로
Next, we will hear from Judge Shoji from Japan. We will watch the video.
Question 3. Since running data is mere information or mere material, running data can't be in a computer program. Then, how about any other information equivalent to a computer program? It means to have similar properties to programs in terms of prescribing computer processing, so that mere presentation of information such as running data can't obtain patent eligibility. On the other hand, according to Examination Handbook for Patent and Utility Model of JPO, data structure satisfies the condition I mentioned, and it can obtain patent eligibility as any other information equivalent to computer program. About algorithm, creation of mathematical theorem as mere arbitrary arrangements or mere mathematical formula can't be an invention, which means creation of technical ideas utilizing the law of nature. On the other hand, a trained model that can be evaluated as information processing by the software is completely realized by using hardware resources can be deemed as a program or any other information equivalent to computer program.
예, 답변 감사드리겠습니다. 예, 이어서
Thank you for your answer. Now we will hear from the Korean panel, Haejin Lee.
대한민국에서는 학습 데이터나 알고리즘
Well, Korea recognizes in Korea, well, the algorithm itself cannot be an invention, but if it is stored in a device or a medium, then it may be patentable. So the claims of the storage device or the computer device can be included in the claim. So a computer readable medium that records data structures such as structure A, B, and C, etc., operated in a computer may be an example of a claim. And recording medium that is readable with a computer recorded with a computer program that runs with means or function A, B, C may be an algorithm claim. So when it comes to AI-related inventions, learning data and algorithm are important elements that determine the performance of the technology. As the process outcome may vary depending on the factors such as type, nature, quantitative size, and qualitative level of learning data, the type and complexity of the algorithm, and the number of layers, there is heightened awareness about the importance of learning data and algorithms, so it will need protection under patentability. Thank you.
그럼 이어서 영국의 리처드 미드 판사님의 답변을
So now let's hear from Richard Mead.
Thank you. In the EPC, there is no specific legislative provision for artificial intelligence, and they therefore have to be considered in the category of computer programs generally. But the European Patent Office's guidelines do contain a lot of information about how AI inventions are handled, and they include examples of inventions which can be claimed. So one example they give is the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats. And that's an example where a technical contribution is achieved. And the technical contribution in question is the monitoring and gathering of that information. And another example that they give in the guidelines is the classification of digital images, videos, audio, or speech signals based on low-level features such as edges or pixel attributes. So, as I say, there are concrete examples, and there's no, in principle, reason to deal with AI as a separate category from computer programs, and they therefore can be patented as long as they don't attempt to claim the algorithm as such, and also noting that it's not enough to obtain a technical effect just that the algorithm is included on a physical storage medium. There has to be a technical effect in the real world. Thank you.
예. 미드 판사님 답변 감사드립니다.
Yes, Judge Mead, thank you for your answer.
EPO에서
The EPO
기술적 기여가 있어야 하고 기술적
shows that technical effect and technical contribution are required for patent eligibility.
첫 번째 주제에
So,
대한 질문과 답변을 마치고
we heard all of the answers for that
주제로
question. Now let's move on to the second topic.
두 번째 주제는
So, second topic is the patentability of AI-related inventions. In AI-related inventions, the importance of learning data and algorithm are gaining increased recognition. However, there is discussion about whether such learning data should be regarded as information and algorithm be treated as mathematical formula, so that they should be excluded in the judgment of invented step. So there is a discussion about this. With regards to learning data and algorithm, 1-1 and 1-2 questions, we'll put it together. First, please explain whether your country deems learning data as an element subject to invented step determination of an AI program. Secondly, if there is a case where the only thing that differentiates the invention described in claims and publicly known prior art is the data, while other features and functions, means, and steps are of the same kind. In this case, can an invention obtain the novelty, an inventive step, only with the difference of such data? So please limit your answer to 1 minute. First, to Judge Humi from China.
According to the patent law of the PRC, the inventions are used in this law means inventions, utility models, and designs. The invention refers to any new technical solution relating to a product, a process, or improvement for. Generally, if learning data is an integral part of the technical solution, it will be subject to inventive step determination. If the difference in data is not enough to make substantial difference between technical solution in the claims and the prior art, the invention can't obtain novelty only with the difference of such data. Thank you.
예, 답변 감사드립니다.
Thank you very much for that answer.
필수 요소로
So as an essential
데이터 정보가 필수
component,
요소로 인정이 되고
if the data is recognized as essential component and when there's differentiation with prior art, there is a possibility of it being recognized for inventive step. Next, we'll hear the answer from Shamusoji through videos.
AI generated inventions. 1. Running data and algorithm. Common question 1, 2. Since running data themselves are mere information, it seems that such a claimed invention can't obtain the novelty and an inventive step. However, according to the examination guidelines of JPL, an invention that has characteristic relating to modification of training data and processing of training data can obtain the novelty and an inventive step. Accordingly, in the AI robot cleaner system case, where all elements other than learning data A are identical, if the learning data A has the characteristic I mentioned, the invention can obtain the novelty and an inventive step in Japan.
네, 답변 감사드립니다.
Thank you very much for that answer.
이어서
Next,
한국의 이혜진 고판사님의 답변을
we'll hear the response from Judge Lee.
행정부부 436 판결은 특허법상 발명에 해당하는 용어에
So Supreme Court decision 2009-436 held that patent eligibility of an invention should be determined based on the entirety of what is claimed. Further, in Supreme Court decision 2005-3284 held that when a claim of a patented invention is comprised of more than one element and elements are organically combined, the technical idea of the whole claim is the substance of invention subject to the inventive step analysis. Therefore, in determining inventive step of a claimed invention, it is not encouraged to disassemble the claim into a number of individual elements and then examine whether each separate element is publicly known or not. Thus, the Supreme Court decided that an inventive step of a patent invention shall be determined based on the entirety of the invention in its organic combination. Considering this, as to AI program inventions, the learning data disclosed in the claim shall also be subject to the determination of inventive step as a part of the whole organic combination. Further, as stated above, that the learning data itself is independently patent eligible in the form of a claim. Next, we'll move on to Professor Judge Mead from UK.
Thank you very much. In the law that we apply in the UK and the European Patent Office, the exclusion under Article 52 for computer programs as such is separate and different from the assessment of inventive step. And as long as a method or product claim which includes a computer program has the required technical effect, then inventive step is assessed taking account of all elements of the claim, including any computer program or learning data or similar. And therefore, the answer to the question is that learning data is part of the consideration for inventive step, and it can provide the necessary differentiation from the prior art. Thank you.
네, 답변 감사드립니다.
Thank you very much for that answer.
판단의 대상이 될 수도 있고
So it can be subject to inventive step determination, and where there is technical effect, then inventive step can be recognized. And so,
이어서 학습 데이터에
Next,
이어서 알고리즘 관련된 질문을
moving on
드리도록
from
하겠습니다.
the learning data, we'll move on to the algorithm.
예. 먼저
First.
인공지능 프로그램 발명의 진보성 판단에 있어서
Please explain whether your country takes an algorithm subject to inventive step determination of an AI program invention.
데이터에 관한 질문과 마찬가지로
Like the question on the learning data,
발명을 비교해 봤을 때
the when compared with publicly known prior art, if everything else is the same and there is only the difference in algorithm, can, based on the algorithm alone, can novelty or inventive step be recognized? So please limit your answers to 1 minute.
먼저 중국의 후미 판사님 답변을
So,
부탁드립니다.
Judge Humi, you go first.
Under the current patent examination system in China, if an algorithm can be combined with a specific device or can be applied into a specific technology scenario to solve technical problem, then such a algorithm can be subject to inventive step determination of an AI program invention. If different algorithms lead to different technique solutions, the difference in technique solutions makes claims of the patent application inventive. Thank you.
Thank you very much for that answer. In China, algorithm for a particular, if it is combined to a particular device or scenario and it can solve a technical problem, then its inventive step can be recognized. And so we'll hear the answer from Judge Tamochi from Japan.
There are no precedents in Japan. In my personal opinion, if algorithm B has not been previously used with respect to solving problems in the specific technical field that the invention belongs to, the novelty and an inventive step of the invention can be recognized with such a difference in algorithms.
Thank you for that very concise answer. And now we will hear the answer from Judge Lee from the High Court. When it comes to AI-related inventions, there's a growing awareness of the importance of learning data because the processing results can vary depending on the type, nature, and quantitative size. The CNN that has enhanced the function of artificial intelligence is used. If an application abstractly recites a type of algorithm without more, it will be difficult to recognize as an inventive step based on the difference of this only. However, the performance of the AI would depend on the layer and the complication of the algorithm. And so if the kind of algorithm is indicated in the claim, then based on such difference in algorithm, inventive step can be recognized. Thank you very much for that answer. Now we'll hear from Judge Mead from UK.
Thank you. Yes, the answer to this question is that in principle, the inventive step can reside solely in the algorithm, as I explained previously. It is worth saying that the European Patent Office assesses inventive step by what is called the problem and solution approach, and it therefore would be necessary that the algorithm should achieve some actual technical advance compared with the algorithm in the prior art. But the answer to the question is that in principle, even if everything is the same between the patent claim and the prior art apart from the algorithm, then inventive step can reside in the nature of the algorithm. Thank you.
Thank you very much for that answer. The performance of the algorithm and the function of the algorithm can actually lead to a decision for inventive step.
Thank you. Now let's move on to the second sub-question of the second topic. It's about person having ordinary skill in the art, VOCITA. So with the advancement of AI technology, there are talks that in the near future, an AI that can learn all prior art, so machine having ordinary skill in the art, VOCITA might replace VOCITA. This is the talk of the day. So common questions 2-1 through 4 will be asked together. There are many questions. So first, please inform us of the determination criteria to confirm the technical level of the VOCITA and the prior art in your country, and explain whether the recent development of AI technology has impacted the determination criteria stated above. Second, please explain the degree of technical level of VOCITA, well, with the relation to the case of the cleaner robot example that we have explored, and the scope of prior art that should be considered, and also the technological level of Fosita will be more advanced and the scope of prior art is to be expanded due to the development of AI, which will make it more difficult for an invention to be granted a patent. Please inform us of your opinion thereon. So we have allotted 3 minutes for each response for this question. So we'll hear from Judge Humi first.
Well, two questions before. According to the guidelines for patent examination, first refers to a hypothetical person who is assumed to know all of the common technical knowledge in the field before the date of filing or the prior date, to know all of the prior art and is capable of conducting routine experiments before above-mentioned date, but not being creative. If the technical problem to be solved leads to the person to seek technical means in other field, the person should also have the above-mentioned capacity. According to the patent law of the PRC Article 22, the prior art referred to in this law means any technology known to the public before the date of filing in China or abroad. The prior art includes technology publicly published in domestic or foreign publications, publicly used or otherwise known to the public at home or abroad prior to the filing date. The prior art should be available to the public before the filing date and includes contents from which the public can learn substantive technical knowledge. In China, at the legislative level, the recent development of AI technology has not impacted the determination criteria stated above yet. For the questions 2, 3 to 4, in China, the Patent Office of CNIPA is responsible for patent examination. As a judge, my opinion may not be so professional. With the progress of the time, the development of technology and the scope of prior art will definitely expand. The AI is also part of the technology. The AI definitely have influence on patent licensing, but it's difficult to predict the scope and the degree of the influence. So perhaps it might be easier to acquire patent licensing with the help of AI, not more difficult, is my opinion. Thank you.
예, 답변 감사드립니다. 예, 다음으로
Thank you for your answer. Now we will listen to Judge Tamuchi. Thanks.
2. Person having ordinary skill in the art. Common question to 2. In Japan, Patent Act stipulates definition of the proceed as a person ordinary skilled in the art of the invention. Article 29, paragraph 2. A person ordinary skilled in the art means a hypothetical person who meets all the following 4 conditions. 1. A person who has a common general knowledge in the technical field. 2. A person who is able to use ordinary technical means for research and development. 3. A person who is able to exercise ordinary creativity in the selecting materials and modifying designs. 4. A person who is able to comprehend all the matter in the state of the art in the technical field, and comprehend all technical matters in the field relevant to problems to be solved by the invention. Accordingly, the degree of technical level of the facilitator in the case above should meet all conditions I mentioned in the technical field of the arena. Common question 2-3. In Japan, the scope of prior art to be considered is required to all the following conditions 1 to 4. That is, 1. Relation of technical fields. 2. Similarity of problems to be solved. 3. Similarity of operation or functions. 4. suggestions shown in the content of prior art. Accordingly, the scope of prior art to be considered on the case above need to contain cleaner field, robot field, and AI program field.
예, 쇼지 판사님 답변 감사드립니다. 그러면 이어서
So thank you very much, Judge Shoji. And now we'll listen to the answer from the Korean judge, Judge Lee.
프로그래밍의 진보성은 통사의 기술자, 즉 토진파의 기술 수준에 근거하여 판단하고 있습니다.
So the inventive step of patent invention is determined based on the technical level of the POSITA. As AI technology advances, it is being discussed whether the person with ordinary skill in the art POSITA can be replaced in the near future by a machine having ordinary skill in the art. Hereafter, the POSITA AI, which is an artificial general intelligence that can learn and practice all prior arts. Such a shift from POSITA to MOSITA would not be considered as an abrupt and unprecedented change under the Patent Act. The hypothetical concept of POSITA can sufficiently help to carve out the concept of MOSITA. In practice, we see that a POSITA is a hypothetical person under the Patent Act that possesses the general technical knowledge in the relevant technical field and who can collect all the information in the state of art in the field relevant to the technical problem of the invention before the filing and make it his or her own. Therefore, as technology advances, it is expected that the level of the POSITA would also rise to a higher level. Additionally, a composition that belongs to a different technical field, but a POSITA can easily utilize, can be used as a prior art to deny the inventive step of a patented invention. As convergence technology advances, the boundaries between technical fields have continued to blur. For these reasons, the expansion of the scope of prior art is also predicted.
특허법상 예견하지 못한 급격한 변화라고 보기는
So, such a shift from POSITA to MOSITA would not be considered as an abrupt and unprecedented change under the Patent Act. The hypothetical concept of POSITA can sufficiently help to carve out the concept of MOSITA.
더 뛰어난 인공지능이 출현하는 특이점.
So, personally, I do not expect substantial changes in the standards for determining an inventive step of patent applications until reaching the singularity at which AI exceeds the sum of intelligence of all human brain power. However, as AI technology advances, the technical level of the POSITA is expected to go up and the scope of the prior arts to expand. As such, the technical level of a POSITA and the scope of the prior arts are expected to present important legal issues in lawsuits in the future.
슬라이드에서 보는 바와 같이
As you can see from the slide, in the case of the invention of a robot cleaner in which AI technology is used, who should be the POSITA? In my personal opinion, along with the robot cleaner technology, the IoT technology, and the AI technology, the person that has all these technology will be POSITA. The prior arts to be considered would also include the aforementioned technologies and their adjacent fields. In reality, experts from these said technical fields team up to develop AI robot cleaners, such as the example that we have seen. Then the POSITA may also be such a team of experts. That is all.
네, 답변 감사드립니다.
Thank you very much for the answer.
그럼 이어서 영국의 리처드 미드 판사님의 답변을 듣도록 하겠습니다. 부탁드립니다.
Judge Mead, it's your turn now.
Thank you
very much.
네, 감사합니다.
The skilled person or the skilled addressee is a fundamental concept in UK and European patent law. We refer to the skilled addressee, but in appropriate cases, the person of skill in the art can be a skilled team incorporating multiple disciplines, and in advanced fields of technology, that is very commonly the case. The skilled person possesses the common general knowledge of their field. They do not have necessarily knowledge of all of the prior art unless it is common general knowledge, and they're not entitled to consider items of prior art together unless it would be obvious to combine them, and I'll say more about that in just a moment. We assess who the person of ordinary skill is from factual evidence about what teams are working on the relevant problem in the real world, and we also combine that with drawing inferences about the task that is set by the patent in suit to implement its teaching, and it's to be inferred that the person of skill in the art has adequate technical training to put the patent into effect. The person of skill in the art has a concept that has had to be adapted for appropriate technology many times over the years. For example, in relation to genetic engineering, it was necessary to reassess the court's approach. I'm sure there will be a fresh assessment for AI, but I don't think there will be fundamentally any different approach taken. The technical level of skill or qualification of the skilled person depends on the field in issue, and no doubt for artificial intelligence inventions, that person will have a postgraduate degree or a doctorate. So far as the scope of the prior art is concerned, I've already said that the skilled person is not deemed to know all of the prior art. They're only entitled to consider pieces of prior art one at a time. But in principle, prior art from any field at all can be considered and can be put forward by somebody who's attacking a patent, because the policy of our patent law is that people must be free to work any item of knowledge available to the public, and therefore there is no conceptual limit on the prior art that can be cited, although if it's not from a relevant technical field, then the court may consider that the ordinary skilled person would simply reject it and not carry it forward. I don't myself think that there's any danger that the high degree of skill required in this field will change the requirement for inventive step, because the skilled person may be very, very highly skilled, but as a conceptual matter in our law, they are completely lacking in any inventive characteristics, and therefore this shouldn't make a difference to the assessment of inventive step. Thank you.
예, 답변 감사드립니다. 예, 통상의 기술자는 예, 진보성
Thank you for your responses. So, FOSITA also is a very important criteria when we examine the specifications of the applications also. So, please look at the reference book for more details when it comes to the response from the judge, Richard Mead, and it gives a very interesting light on this case, and the fact that FOSITA does not have to be aware of all prior art is a very interesting comment from Judge Mead. Thank you. So we will move on to the last sub-question of this second topic about the specification requirements. When it comes to AI program invention, learning data and algorithms are rarely specifically mentioned, but rather they are recited in a vague manner. So whether the applicant can properly fulfill this element is an issue. So here comes two questions with regards to this topic. Regarding the requirements for the specification, please introduce if your country has any criteria. And when it comes to AI program invention, if learning data and algorithm are not definitely specified in the specification, does this violate the requirements for the specification and claims in your country? Please limit your answer to 2 minutes. We will first hear from Judge Humi from China.
For common questions 3.1, the answer is according to the patent law of the PRC Article 26, specifications shall set forth the invention in a manner sufficiently clear and complete so as to enable a person skilled in the relevant field of technology to carry it out. Where necessary, drawings are required. The abstract shall state briefly the main technique points of the invention. The claims shall be supported by the specification and shall define the extent of the patent protection sought for in clear and concise manner. For comments question 3.2, according to the patent law of the PRC, the fundamental requirement for the specification and claim is that a person skilled in the relevant field of technology can carry out patent technology in light of the content of the specification, solve the technical problems, and produce a designed technical effect. In the case above, if there is no specific learning data and an algorithm in the specification so that the person cannot figure out the technical solutions, then the patent specification is deemed as a violation of the requirements for the specification. Thank you.
예, 답변 감사드립니다.
Thank you for your answer. So, if technical solution cannot be figured out based on the specifications, that it would be a violation of the requirements for the specification,
이어서 일본
according to your answer. Thank you. And now we will listen to Judge Shoji.
3. Requirements for specification. Common question 3.2. In Japan, with regard to the requirements for the specification, Patent Act provides 3 requirements such as enablement requirement, support requirement, and clarity requirement. If it is not specified as running data A and algorithm B, but simply disclosed as running data and an algorithm, it would be a violation of enablement requirement and support requirement in Japan. The reason is as follows. Enablement requirement. A case in which although technical procedures or functions are stated in the claims, the detailed description of the invention does not state how such technical procedures or functions are executed or implemented by hardware or software, and yet in which the claimed invention can't be carried out because a person schooled in the art can't understand the invention even based on the common general knowledge at the time of filing. It would be a violation of enablement requirement in Japan. About support requirement. If the running data or algorithm is mere abstractly specified in the claim and not specified running data in the detailed description of the specification, and a person skilled in the art can't understand what the invention is even based on the common general knowledge at the time of filing, that would be a violation of support requirement in Japan.
네, 답변 감사드립니다.
Thank you for your response. Now we will listen to Judge Lee.
최근 들어 전 세계적으로 AI 관련 프로그램 발명이 급격히 발전하면서
Recently, as the number of AI-related program inventions is growing rapidly across the world, the number of relevant applications has also increased. And there is heightened awareness about the need for protection of such inventions. But as you can see from the slide, most of the program inventions are written in a means plus function form or a step plus function. And many times the claims are broader than what has been actually invented. Also, many patent specifications do not set out the learning data or algorithm in detail, making it hard to specify the scope of protection for the invention in many applications. Only a few program inventions specify their source codes. Rather, they just only disclose a simple flowchart or a representative user interface, UI, or one or two user experience-related drawings. It is unclear how these programs can actually be practiced. In the past, most program inventions were written in the means plus function claims and consisted only of abstract ideas, and such applications were often rejected and invalidated in Korea. But there seems to be no precedent yet as to AI program inventions. In this case, the learning data and algorithm are not specified, and if specific means or process to create learning completion model is not included, then FOSITA will not easily be able to practice based on specifications only. So this would be a violation of the specification requirements. Such AI program inventions are different with other inventions in that language and diagrams are insufficient to clearly deliver how it works. So in order to suit such nature of AI program inventions, the determination criteria and evaluation standards should be amended. Thank you.
네, 답변 감사드립니다. 그럼
Thank
이어서
you.
영국의 리처드 미드
Now,
박사님
Judge
답변을
Mead,
부탁드리겠습니다.
please give your answer. Thank you.
Thank you. The relevant statutory provision is Article 83 of the European Patent Convention, which is transposed into UK law in our Patents Act, and it requires that the skilled person is able to implement the invention from the description and using their common general knowledge across the whole scope of the claim without undue effort and without exercising any invention. And that requirement is general and applies to inventions of all kinds, not just AI or computer programs. The specification is required to set out the way to implement the invention in ordinary language, and it is not preferred to include source code. The requirements of the EPC examination guidelines express a preference for ordinary language, which may include flowcharts, and it's permitted to include source code, but it's not required, and it's not encouraged, and it's not permitted as the only means of enabling performance of the invention. These requirements of enablement across the scope of the claim are very fact sensitive, and there's no absolute requirement. I don't believe there's any decision absolutely about the level of specificity with which an algorithm must be expressed. But in the particular situation explained in these questions, where there is simply a disclosure of learning data and an algorithm, then it's easy to imagine that the requirement of Article 83 would not be met because the skilled person would need to use undue effort or invention to implement the claims. Thank you.
예, 영국 미드 판사님 답변 감사드립니다.
Judge Mead, thank you so much for your answer. So that it was the last response for 3-1 and 2. So now let's look at the video that Raymond Chen, a judge from the U.S. court, sent us. So we will only show a part of it, but you can access the full video through a link that will be provided later. Thank you.
Thanks. So, Mark, I think you wanted us to move on to patent eligibility questions.
Yes.
Here in the United States. And so I'll just go ahead and first take the lead on this question. And when it comes to patent eligibility for AI inventions here in the United States, I think the first fundamental question that has to be addressed, and the most pressing question, is really what is the current state of our law on the eligibility of computer implemented inventions. You could also call them computer software inventions. So to understand what will happen to the patentability of AI inventions, we need to know what is the law for computer software. And unfortunately, that's not an easy, straightforward answer at the moment in light of a few very important consequential Supreme Court decisions in the past decade on this issue. The Supreme Court has really changed the legal framework for how we in America must think about patent eligibility across all technologies. But one of the very most impacted fields is certainly computer software. Now, Section 101 of the US Patent Act governs the subject matter eligibility requirements for all patents. And under Section 101, whoever invents any new process, machine, manufacture, or composition of matter can obtain a patent. But the courts at the same time have long interpreted this provision as excluding so-called abstract ideas, laws of nature, and natural phenomena from being patent eligible. And software patents invalidated under Section 101 are typically deemed ineligible as being directed to mere abstract ideas. And understanding what the Supreme Court means by its abstract idea exception has proven to be a very difficult exercise for lower courts, including the Federal Circuit, as well as the USPTO, to apply to individual cases. And although what constitutes an abstract idea is not straightforward, the Supreme Court has stated in cases like Bilski and Alice that fundamental economic practices long prevalent have been deemed to be an abstract idea. In addition, the mental steps doctrine, which states that activity that can be performed through an ordinary mental process in the human mind or using a pen and paper are also alone without anything more in the claim is ineligible for patent. And furthermore, claims that are drafted in a result-oriented manner that lack implementation details for achieving a desired result are also regarded as directed at being mere the abstract idea of the desired goal or result itself. And let me see if I can give you an example of that. The very first example in a United States court decision is the Wyeth versus Stone case from 1840, where the inventor there had invented a technique for cutting a very large block of ice into equal smaller sizes. And in the 1800s, ice was very important. It was the only way to keep things cold. Refrigeration had not been invented. And so this particular inventor had invented a specific technique to cut ice in equal sizes. And he had one good claim, which claimed a method of cutting ice based on what he disclosed in his patent. But then he had a second claim, and the second claim said a method of cutting ice by any means, regardless of means. And that second claim, that very broad claim, was struck down by the court in that case as being so broad as to cover just the abstract principle of cutting ice. And because it failed to recite in the claim any means of cutting the ice, it was deemed essentially to be an abstract idea. And I think that 1840 decision is really the origin of the abstract idea exception. And so the principle behind the abstract idea exception is to prevent inventors from drafting claims at such a broad generic level that the claim it preempts an entire field of inquiry because it claims the result itself. In this particular instance, in Wyeth v. Stone, it's the result of cutting ice into equal sizes. So getting back to computer software inventions and their eligibility, this has been an issue in the United States for at least 60 years. In the 1960s and 70s, the USPTO regularly refused to grant patents on computer software inventions, believing that they were just directed to abstract ideas occurring inside a hardware machine. And then in the 1990s, it appeared that the Federal Circuit had settled the issue by concluding that a programmed computer that produced a new useful result should be just simply understood as a special purpose machine that qualifies under Section 101. But now in the past decade, the Supreme Court has overruled that generous view of the law and is now demanding a much more rigorous inquiry, while at the same time not providing much guidance to us lower courts on how to apply that more rigorous inquiry. So in response, the Federal Circuit has done its best to piece together a new framework to and and asks that we look at the patent claim as it's drafted to see if it really provides any kind of specific implementation for accomplishing a technological process. So some commentators have likened the current state of patent eligibility law to Europe's technical effect requirement for patents. So when we at the Federal Circuit look at examples of computer implemented invention patents, that there are times where they actually disclose in the patent specification a patent eligible computer software based technical improvement to some kind of computer technology. But the patent claims are unfortunately drafted at just simply too high a level of generality, such that the claims don't specify adequate implementation details, thereby leading to a conclusion that the claims are just simply too abstract. And because artificial intelligence inventions are at their heart computer implemented inventions, AI will likely face similar challenges in claim drafting to ensure that they're not claimed in a generic, vague way that fails to specify the particular means of how the artificial intelligence is actually accomplishing its tasks and what the artificial intelligence actually is, as opposed to merely what it's accomplishing. And that same challenge will likely be true for any invention that the artificial intelligence itself produces. There will be a challenge in trying to characterize what that resulting invention is, as well as what are the specifics that that resulting invention performs, what steps that it undertakes. So I heard Professor Lumley talked about an example of a self-driving car relying on artificial intelligence. And so you can imagine a claim that's drafted to a self-driving car in which, and the claim says, wherein artificial intelligence self-learns on how to safely drive a car while navigating through traffic, period. And if the claim is drafted at that level of generality, then there's a very real risk that a claim like that could be struck down as being just to the abstract idea of using artificial intelligence, whatever form of artificial intelligence that may be, that will control a car to be driven safely through traffic without really providing the real implementation details. So that's the challenge we're at, that we face here in the United States with the abstract idea exception. It comes down to really understanding at what level of specificity must a claim be drafted at in order to avoid this abstract idea invalidity problem. So I'll leave it at that. And
maybe I'll jump in at that point, because I think it's I think everything Judge Chen has said is correct, both about the sort of contours of the law and also the challenges and the difficulty of applying a pretty vague standard here. I do want to note a couple of reasons to think that this may be particularly challenging for AI. The example that Judge Chen gave is a good one. There is a strong incentive, I think, all things being equal, for patent lawyers to try to write their claims very broadly, particularly in a rapidly developing field like AI, because they don't know exactly how the algorithms will work in the future, and they want to have effective protection. that instinct runs directly up against the abstract ideas limitation, though, right? And I think that's particularly true with AI, because it's not just that I don't know how other people might develop technology in the future. I don't even know for sure how my own AI will develop technology in the future, right? One of the great benefits and interesting things about machine learning algorithms is they may well develop and move in directions that their sort of human creators don't predict. You create the initial conditions of the algorithm, you get the training data set, but it might be that the right way to navigate safely through traffic is something the AI comes up with that nobody really had in mind. Now, I think that presents some problems for trying to protect the AI itself. You can solve the problem of abstract ideas as a patent claim drafter by writing a very narrow and specific claim, identifying the specific way you solve the problem and the specific algorithm in a normal software case. It's much harder to do that if you don't yourself know how the algorithm has solved the problem. And I think that is compounded by the fact that the algorithms themselves are going to change and refine how they solve problems as they learn. And so one of the real challenges for patenting AI is not the question of, is AI ever patentable? I think if it meets the doctrinal limits that Judge Chen suggested, you can get a patent on artificial intelligence. But if you want an effective patent on artificial intelligence, you've got to confront the problem that I can't just claim the result. I can't just claim navigating safely through traffic or translating words. And I may not know enough to describe or claim at a level of detail precisely how it is the AI is going to solve that problem. Even if I do know how my AI works right now, from a patent enforcement perspective, what I really need to know is how will things work 5 or 10 years from now. It takes several years to get a patent through the US Patent and Trademark Office. Then you go into litigation, which can take several more years. And so I think one of the things that is a real problem for using patents to effectively protect AI is that the nature of the AI is not transparent, may change very quickly, so that even if I find that right level of abstraction, I may draft a patent that covers very well what my AI does today, but won't necessarily cover very well what my AI or anyone else's AI does 6 months from now. And I think for that reason, we may see that trade secret protection is used more and more than patents, at least among competitors. That doesn't mean we won't get patents and then we won't see patent lawsuits. And we will confront all of these Section 101 issues. But I think one of the more effective ways of preventing people from sort of copying your AI system is going to be to try to use trade secret law, because trade secret law gets automatic protection and it doesn't take sort of years to get through the patent office, and it makes a virtue of the thing which patent law makes a problem, which is that it's not obvious how my AI works. It's not transparent to anyone. That's a bad thing from patent law's perspective. Our doctrines in Section 112 require you to teach people how the AI is working. But it's a good thing from trade secret law's perspective. If I can keep it secret, then I can get effective protection. The big limitation for trade secret law is that it applies only to people who take the idea from me. So we've seen already sort of one high-profile AI trade secret case between self-driving car companies when Google's Waymo division sued Uber, saying that one of their chief scientists had left and taken documents to Uber, and they ended up preventing him from working and kind of shutting down the line of work he was engaged in. So that may be an effective way of getting intellectual property protection in the subset of cases where someone takes the idea from you. It won't give you protection against people who independently develop their own AIs.
네, 미국 패널 분들 첸 판사님과 렘니 교수님.
Yes, Judge Chen and Professor
경청해 주셔서 감사합니다.
Lemley, thank you.
보신 대로 미국에서도
As we have seen in the video, The claim and specification requirements, when it comes to that issue, the abstractness or vagueness of the claims are becoming a problem, and abstractness is being addressed by narrowing down the scope of the claims, but through self-learning, how AI solve the problems may change within a matter of 5 years or 10 years. It is very difficult to regulate that matter currently and limit the claim scope. So we have to address the question of whether that will be practicable a decade after today. So yes, that was addressed in his talk, and thank you for your response. And now we will move on to the third topic. We are a little late on time, so we will try to move as swiftly as possible. So the third topic is issues on patent laws for AI-generated invention. In most countries, following the principle of inventorship, the inventor has the right to acquire a patent. But how is a joint inventor interpreted? And if AI join the invention, then how will that be addressed? So common question number 1 goes as such. What is the criteria for recognition as an inventor in your country? And particularly, please introduce how the minimum requirements of contribution to become a joint inventor is interpreted. Please limit your answer to 1 minute. In the third and fourth session, Judge Param from Australia is joining us. So we will start with Judge Param. Thank you.
Thank you, Judge Wu, for your kind invitation. In this area, the matter is governed by the Patents Act 1990. It does not define an inventor, but the case law which has developed around the word used in the Act has indicated that an inventor is a person who makes a material contribution to the invention. It follows that concepts like joint inventorship are also recognised. There will be joint inventorship where 2 or more persons have made a material contribution to the invention. The contribution does not have to be the same contribution. It can be separate, and it can occur at different stages of a process. Obviously enough, it also includes collaboration.
Thank you very much for that answer. As material contribution, this requirement was explained to us. Next, from China, Judge Humi. So please limit your answer to 1 minute.
According to the implementing regulations of the patent law of the PRC, Article 13, inventor, as mentioned in the patent law, means that any person who has made creative contributions to the substantive features of the invention creation. Any person who, in the process of accomplishing the invention creation, is responsible only for organized work, or who offer facilities for the use of the material resource, or who take part in other auxiliary functions should not be inventor. The substantive features are the key technique features that reflects the difference between the invention and the prior art. The creative contribution refers to innovative intellectual labor. In China, the person who makes innovative labor is the inventor.
Thank you very much for that answer. Next, Judge Gangnam Kim from Korea, please. Thank you very much. According to the Patent Act of Korea, with regards to the definition of an inventor, there is no separate provision. And so based on case law, those who have contributed to the creation of technical idea is required to be defined as an inventor. And so not only the provision of simplified task or idea, it is not enough. The Korean Supreme Court rules is that if new ideas are specified through tests and thus materially contributes to the creative act, this is seen as an inventorship. Thank you very much for the answer. And now going to UK, Judge Mead.
Thank you. The definition of inventor for the UK is to be found in Section 7 of the Patents Act 1977, and it says that the inventor is the actual deviser of the invention. So it has to be somebody who has done real and specific work. There's very little guidance in our law about exactly how much work is necessary for a person as part of a team to make as a contribution as an inventor. One reason why this isn't explored very deeply is because it isn't a ground of revocation of a patent in the UK on its own that the invention. So this is not always a very important practical question, but the simple answer is the deviser of the invention under Section 7.
예, 답변 감사드립니다. 그러면 공통 질문 2와 3으로 넘어가도록 하겠습니다.
So now we'll move on to common question 2 and 3. Now we will look at the specific case on the pharmaceutical invention and talk about the issue of joint inventor. Please refer to the table for the specifics of the case.
위 사안에서 A와 B가
In this case, if A and B are natural persons, who does your country deem to be the inventor of this invention? And moving on, if B was an AI, in this case, then can A be deemed as an inventor? Please limit your answer to 2 minutes. First, we will hear from Judge Parham from Australia. Thank you.
So this question would be seen through the prism of the material contribution test I referred to before. And that has been fleshed out by decisions of the full federal court in Paulwood and in the Gray appeal, making the assumption that the assumption in the question that A provided B with abstract tasks and ideas is one which would satisfy the material contribution test, which seems sensible. Then the conclusion would be that both A and B are inventors for those purposes. Then turning to the second question, where B is switched from being a person to being an AI, the situation in Australia is perhaps a little out of step with other jurisdictions. It appears at the moment that the answer to this question would certainly be that A was an inventor, or at least arguably be that A was an inventor, but there is a complexity in that there is a decision of the Federal Court of Australia in Thaler, Justice Beech's decision, that would hold that B was also the inventor. That case didn't actually have to decide whether A was the inventor, but it seems a likely inference from it that it was. That's a controversial decision. It's under appeal at the moment. I may have to sit on the appeal, so I will be circumspect in my remarks. But those are the answers I would give.
네, 답변 감사드립니다.
Thank you.
이어서 중국의
Now, Judge Humi from China, please go ahead.
For common question 2, in China, B would be regarded as an inventor, as that B made the creative contribution. His work is concrete. However, if A can prove the concreteness of the ideas, not so abstract, it must be concrete. A also can be regarded as co-inventor. For common questions 3, according to the patent law PRC, the inventor refers to natural person, namely human beings, does not include AI. Currently, AI is regarded as a executor of algorithm program, which is a tool to help human beings getting intellectual achievement. In the above-mentioned case, although AI generates the final output, A, as a human being who provides the idea, may be the inventor. Because AI's behavior is not spontaneous, its role is completed and the guidelines of AI is regarded as a tool in this case. Thank you.
네, 후미 판사님 답변 감사드립니다.
Thank you, Judge Humi, for your answer. Now we will hear the answer from Judge Shoji.
Issues on patent rules for AI-generated invention. Common question 2. In this case, person B is deemed to be the inventor. With respect to the similar case, IP High Court ruled that a person who gave general advice or instructions is not an inventor. And then Tokyo District Court ruled that any person who merely gave a research subject or general advice or guidance to the subordinate researchers without presenting any specific conception can't be an inventor. With respect to joint inventor, the IP High Court on the above ruled as follows. In order for multiple persons to become joint inventors, such persons must make a substantial contribution in the process of conceiving of an idea to solve the problem and giving a concrete form to the idea under an integral and continuous cooperative relationship. From the viewpoint of those decisions, since person A, who only provided B with abstract tasks and ideas, does not make a substantial contribution in the process of conceiving an idea to solve the problem and giving a concrete form to the idea, A is not the joint inventor. Common question 3. My answer is no. The reason is as follows. In the case of AI conducted what B did in the above case, since only AI was involved in the creative activity of structuring the technical ideas concretely and objectively, enough to enable a person ordinarily skilled in the art to work it. There is no human, that is a natural person, who was involved in the creative activity of structuring the technical ideas concretely and objectively. In Japan, since the Patent Act deems only human as an inventor, AI never becomes an inventor. So, in the above case, there is not any inventor. I think that it needs to be statutory amendment of the Patent Act that a person or an entity who was involved in the creative activity of AI-generated invention can be deemed as an inventor.
네, 쇼지 판사님 답변 감사드립니다.
Judge Shoji, thank you for your answer. Now we will listen to Judge Kim.
감사합니다. 먼저 이번
Thank you very much. First, the second question, natural person A and B, whether they are considered as inventors. So in this case, A is the project manager or the project leader, and he's in a relationship with B. He gives instructions to researcher B. Of course, until the invention comes out, he will give numerous instructions to B. In Korea, we say he's hounding or grilling B. So if we grill him, what happens? This is what happens. So researcher B has burned up black. Do you think an invention came out because of this process? No, I don't think so. So let us ground him or grill him again.
예, 새하얗게
is
불타버렸는데
grilled white.
이때 보통 발명이
Now,
나오는
at this
것은
point, inventions come out, right?
하얗게 불태운 B는
So
현행
B, who has been
법리상
grilled
발명자가
white,
아니라
is considered as an inventor under the current laws. But what about A, who has grilled B to the point of, being burned up? Well, it will depend on the specific facts, and the Supreme Court of Korea has reached different conclusions regarding two similar cases. So in order for A to be considered as an inventor, it does not matter how much he grilled B, it would depend on how he had grilled B. If A had given instructions that had contributed to the technical creation, he would be considered as an inventor. But if he had only given abstract tasks and ideas, then A would not be considered an inventor. Next, question 3. If B was artificial intelligence, can A be considered an inventor? Should we grill or hound an artificial intelligence, AI? Yes. No matter how much he is grilled, the AI is laughing his head off. So as you can see, if we follow strictly the current laws and regulations, then A cannot be considered inventor. However, the requirement to become an inventor, the contribution to the creation of a technical idea, if this is flexibly interpreted, then A can be considered as an inventor. In short, up until now, in the area of chemical inventions, the importance of lab tests was very much emphasized. But because of the advances in AI technology, the importance of these repeated tests have become weakened. And so if the act of providing abstract tasks is becoming more important, it can be considered as an inventor. Next, we'll ask Dr. or Judge Mead from UK for his answer.
My answer to common question 2 is that there is no reason in principle why A can't be an inventor, because an invention can be made in the making of quite a conceptual decision, and it could easily be an invention to decide to attack a particular biological target or to use a new kind of assay in assessing this sort of task. And therefore, the inventive thought could take place either at a conceptual level with A or at the level of actually doing the work such as is conducted by B in this problem. So I don't believe there's a definite answer to this, and it's extremely fact dependent. So I don't think there's a definite answer to this. There's no decision yet in our case law about the situation where A sets an AI to work on the task. We do have a decision about whether the AI on its own can be an inventor, and that's been decided in the context of our Court of Appeals decision in the Davos case, which we're coming to shortly. But my answer to common questions 2 and 3 is that merely because A's input is conceptual doesn't mean that he can't be an inventor, and it depends on the nature of the invention and the split of work between A and B.
네, 미드 판사님 답변.
Judge Mead, thank you for your answer.
아까 보셨던 미국의 첸 판사님과 램리 교수님의 비디오 영상을 3주제와 4주제.
Now we will look at the video of Judge Chen and Professor Lemley on this topic. It will last for about 6 minutes.
So I know we've got just a few minutes left, but I do think we want to talk about the final issue, which is protection for the outputs of AI. And this is an issue that has come up in courts across the world just in the last few months. Is an AI an inventor? Who, and if not, sort of who is inventing the results of this algorithm? Judge Chen, you want to introduce the Thayer case and this problem?
Yeah, sure. So I think everybody here knows that there is a particular person named Dr. Stephen Thaler who has filed patent applications across the world on behalf of his artificial intelligence that he developed. And he refers to this AI he developed as Dabus. And he claims that Dabus, the AI, has itself invented 2 inventions, that Dr. Thaler has filed patent applications for on behalf of Dabus. And some of those applications include filings at the USPTO, and the USPTO refused to consider these patent applications because Dr. Thaler identified Davis as the inventor, not Dr. Thaler himself. And in the USPTO's view, because an application must identify an inventor, a machine or a piece of artificial intelligence can't be understood as an inventor, as that term is used in the Patent Act. So after the agency refused to consider these patent applications, Dr. Thaler appealed that adverse decision to district court, and we have a district court decision here in the United States that affirmed the USPTO's decision in refusing to consider these applications for failing to identify a true inventor. And as I understand the district court decision, it looked to the words of the United States Patent Act, which refers to inventors as individuals. And so the real question comes down to whether a machine can be regarded as an individual. And the district court looked to a Supreme Court case, which had to interpret the word individual in a different statute, in a different context. And the Supreme Court in that case concluded that individual meant a natural person. And so the district court here in the Davis case relied on that interpretation and found that it also ought to apply here in the Patent Act's usage of the word individual. And so therefore, because the Patent Act requires a natural person to be identified as an inventor, that necessarily does not encompass machines like Davis. Right now, we expect a Federal Circuit appeal to be coming soon, but as far as I know, it hasn't happened yet.
And for obvious reasons, we won't ask Judge Chen to opine on what the Federal Circuit would do in a pending case.
Right.
But I am under no such limitation. I think the court's analysis of the statute is right. And one of the things it notes is that not just that it sort of says an individual, which has been interpreted to be a natural person, but that other provisions of the Patent Act require that that individual inventor, quote, believe himself or herself to be the original inventor. And the district judge notes that there's no reason to think that the AI would have a sort of state of mind as to whether it believes itself to be an inventor. And that's further indication that the statute has in mind individuals as human persons, not including AIs. I will note that this is an issue that is coming up across the world. The UK courts have aligned with the United States in this respect, and you may hear from other judges on the panel about this. By contrast, in Australia and South Africa, courts and/or the Patent Office have concluded that AIs can be an inventor. I think that under the current U.S. statute, its inventorship is going to be limited to to an individual, to a person. It will not include an AI. But I also think that's going to be harder to sustain over time as it becomes further and further removed. The invention is less and less connected to anything any individual person did. And if we get to the point where, yes, I built an algorithm and I asked the algorithm to solve a problem, but I didn't myself sort of direct how that problem was solved, and I didn't even necessarily understand the way in which it solved that problem, it becomes harder to call me an inventor. And it may be that Congress at that point needs to step in and decide what to do. And it's an interesting problem because I think under current law, you could find yourself in a situation in which the AI is not an inventor because an inventor has to be a person. But no individual person is an inventor either because they're not the ones who actually did the hard work. Maybe that's okay. AIs don't necessarily need the incentives of the patent system in a way that sort of human inventors do. But my guess is there's going to be strong pressure at the legislative level to try to determine that these inventions are patentable and to assign them to someone, whether it's the corporation who owns the AI or some individual who's connected with it. But that is, I think, for the future, it's an issue we will have to confront. Judge Chen, any concluding thoughts?
No, I just wanted to check, are we out of time now?
Yeah.
Okay, well, then I'll just leave it there and say thank you very much to the conference organizers. I really appreciate the chance to participate.
Thank you, and we hope the conference goes well.
네, 답변 감사드리고 잘 들었습니다.
Thank you so much for your answers.
답변에서 소개되었던
So it was mentioned in their response, the Dabus case. Let's delve into this case.
관련된 사실관계는 이 슬라이드에
So the facts related to the case are here on the slide. Dabus is an AI that was developed by Dr. Thaler, and
문제 해결을 지시하지 않았다라고
he did not give specific guidances and filed application for the AI-generated invention. So if AI generated an invention by itself without any human intervention, then who shall be the inventor? And who shall be the patentee? And under the existing patent law, are there any concerns about a legal gap that might arise in the protection? Given the time constraints, please limit your answer to 1 minute. Thank you. First, we will hear from Judge Perham from Australia.
Well, on the basis of Justice Beech's decision in Thaler, the answer would appear to be that the inventor is the Davis system. As I say, that's under appeal. The answer to who the patentee is not strictly known. Justice Beech thought that the patentee could be the person who owned the system or wrote the software which operated the AI. Under our statute, that a person can be a patentee if they can take an assignment of the patent from the inventor. Justice Beech thought that that definition might be able to be satisfied. There may be some problems with that. Some people may object that an AI cannot own property. In any event, at least while the decision stands, the answers are as I have given.
네, 예. 나이페람 판사님,
Yes, Judge Perham. You shared the case on Dabus recently that came out from Australia. Thank you. And Judge Humi, please go ahead.
It's hard to, the question is hard to apply. In the future, if the year of super AI is coming, the criteria of the qualification of inventor or patentee may be redefined. But in China, it's the authority of legislature, and the judges can't do much about it now. Thank you.
Thank you. Now, Judge Shoji will give his answer in his video.
Question 4. As I mentioned above, only human can be an inventor. The reason is as follows. Article 36, paragraph 1 of Japan Patent Act provides a person requesting the grant of the patent shall submit an application to the Commissioner of the Patent Office stating the following: the name and domicile or residence of the inventor. From the viewpoint of the above provision, since AI has not the name and domicile or residence, AI does not become an inventor. In addition, in Japan, the inventor has the right to obtain a patent at the same time as the invention is completed, and the inventor has a right to obtain a patent can transfer the right before filing the application. It is planned to be a natural person as a person who has right and ability and can be an applicant. From the viewpoint of the above interpretation, under the current law, an AI-generated invention without any human intervention would not be protected by the Patent Act.
네, 답변 감사드립니다.
Thank you for your
이어서
answer. And Judge Kim, please go ahead.
먼저 설문에서는 인간의 개입이 전혀 없음을
First,
주장하고
the basic
있습니다.
premise of the scenario is that there's no human intervention at all. So
특허법상 인공지능은
it cannot be an inventor, and under the current Patent Act, AI cannot be an inventor. So there may be a void as to who is the patentee, as well under the current Patent Act,
공백이 생길 수가 있기
which adopts the doctrine of inventorship. And even if the Patent Act is amended to grant inventorship to AI, the patent right shall be vested
특허는 자연인에게 기속되어야 할 것인데
in a natural person. In this regard, the succession of the rights can also be an issue because AI cannot transfer its rights. So it's my personal opinion that we should legislate in order to grant inventorship to AI, and adding automatic assignment through legislation could temporarily solve the issue. Thank you.
네, 답변 감사합니다.
Thank you
이어서 영국의
for your answer. Now, Judge Mead,
부탁드리겠습니다.
please go ahead.
Thank you. We have had a clear decision in this country from the UK Court of Appeal that AI cannot be an inventor. And the main reason for that is not a conceptual one, but a practical one to do with the fact that our patent legislation gives substantive legal rights to inventors, and legal rights cannot be held other than by an entity which has existence as a legal individual, and AI does not qualify for those purposes. And so it's clear for the moment, unless there's an appeal to the Supreme Court, which I think is unlikely, or a legislative change, that AI cannot be an inventor. And unfortunately, because of the way that Mr. Thaler phrased his application and the court issue, we don't yet have a decision about whether the person who sets the AI to work on a particular task can be an inventor. That's for the future. Thank you.
네, 답변 감사드립니다. 예, 보셨듯이 인공지능이 발명자가 될 수 있는지에 대해서
So, thank you for all of your answers. We heard from UK, Australia, Japan, and Korea, and under the current law, it is impossible. But Australia and South Africa, AI can be deemed as an inventor, but such decisions are under appeal. So, anyone who is interested can take a look at how the case is proceeding and how laws might be amended with regards to this issue. And now we will move on to the fourth topic, which is patent infringement by AI. I will skip the introductory comments and jump right into the questions. So if many parties conducted a patent infringement, then who will be held liable for patent infringement? Please introduce your country's rules on that. And with regards to process, method, invention, if the server overseas was used to make infringement in domestically, then how will that be addressed? And in such case, if part of the act was conducted by using AI, then do the existing discussions apply without change? Please explain and limit your answer to 2 minutes. First, Judge Param, please go ahead.
Yes, in relation to common question 1, there's no particular difficulty with the concept of there being a joint infringement under Australian law, and no complexity attends that. In relation to questions 2 and 3, these questions do not make terribly much sense under our Patents Act. Our Act turns on the exploitation of the patent, which can happen in a variety of ways. It can happen by importation of a product, it can happen by the manufacture of a product, it can happen by the performance of a process, or it can also happen by authorization. But the critical feature of each of those matters is that these are activities which are conducted by legal persons. So there are difficulties from an Australian perspective in integrating the idea of AI being involved in an infringement. So I think my answers to questions 2 and 3 would be that the question can't really be answered under Australian law.
네, 답변 감사드립니다.
Thank you very much for those answers.
퀘스천 2와 3에 대해서는 현재 호주법과에서는
So under the Australian law, the common question 2 and 3 cannot be really definitively answered. Next, we would like to pass the floor to Judge Humi from China.
For common question 1, according to the Civil Code of PRC, Article 1168, where 2 or more persons jointly commit a tort causing harm to another person, they should be liable and severally. In the case of multi-party patent infringement, if more than one person is responsible for the damages, they should be jointly and severally liable. For common question 2, if the ultimate infringement act takes place at home, even if several overseas is used in some steps, it's still be considered as domestic practice of the patent and recognized as a patent infringement according to the domestic law. For common question 3, according to the patent law of the PRC, the juridical status of the AI is not recognized yet. Therefore, even if AI is applied in some steps of patent infringement, it will not be considered as a subject liable for infringement in China. Thank you.
예, 답변 감사드립니다.
Thank you very much for those answers. Next, Judge Kim from Korea. The floor is yours.
네, 감사합니다.
Thank you very much. So there are many challenges involved in patent cases. One of the cases that I really would like to avoid would be infringement by multiple parties, and one that involves territoriality and network invention infringement. Well, with regards to multi-party infringement, there is no established court decision. If I introduce one court decision by a lower court, if one of the multiple parties was controlling or managing other parties, then unilateral liability for infringement can be recognized, and if they colluded together and have practiced together the components of the patent and invention, then all the multiple parties can be recognized as having infringed the patent. And also, network that is based on overseas servers, infringements involving this kind of method, there is no Supreme Court rulings. However, in a lower court, with regards to an act that used an overseas server to engage in infringement about method invention, the implementation method and purpose were considered of the invention in order to recognize the practice domestically of this patent. So I think for infringement by AI, all of these principles can be applied. Thank you very much. Thank you for the answer. Next, from UK, Judge Mead, the floor is yours.
Thank you. There are 2 ways under UK law in which multiple people can be liable for the same commercial exploitation of an invention. One is our general law concerning joint tortfeasors who cooperate together in a single course of action. There's nothing specific to patent law about that. It applies to all torts under UK law. And the second is that under our specific law of infringement under Section 60 of the Patent Act, multiple different kinds of action in relation to an invention can be an infringement as performed by one particular person. So the person who imports an infringing product commits an infringement, and the person who later advertises or sells those products also commits an infringement. So there's no particular difficulty about that. In relation to common question 2, we've had a number of cases where the physical infrastructure to implement an invention has been spread in different jurisdictions, typically, as in this question, where the server in question is not in the UK. And the legal approach of the UK courts is to ask itself where, in substance, the method is being put into effect, and where the method provides a user experience. That's typically where the user is situated, which can well be in the United Kingdom, even if the server executing the code is abroad. And there have been several cases of that. In relation to common question 3, I don't think there's any difficulty in applying these principles where AI is involved, and what the courts will look to is the real person or corporation, the entity with legal personality who causes the AI to do whatever it does. But I don't believe there's any particular problem with that.
예, 답변 감사드리겠습니다.
Thank you very much for those answers.
나머지 슬라이드는 일본과 미국에서 서면 답변 보내주신 것을 간단히 정리를 했습니다.
These slides actually show answers from Japan and the US.
특허 침해와 관련된 것입니다.
Now let's move on to the last question.
주체가 누가 될 것인지에 관한 논의를
It is about who will be liable for the infringement.
발전 유형에 따라서 특허 침해 책임의
So,
주체를
based on the development of AI, who should be held liable? Is it the operator or the developer or the manufacturer or AI itself? Who shall be held liable for the infringement? And in addition, can AI itself be held liable for patent infringement in your countries? Please limit your answers to 1 minute. First, Judge Parham, please go ahead.
Well, as I said before, because the Act requires an exploitation, there'll be no question of the AI being held liable. The person who will be held liable is the person who makes the product or imports the product or uses the method, and that won't be AI. As to the second question, if one were to grant to AI legal personality, it would be a different ball game. In circumstances where we currently hold that an inventor could be an AI, then it would be reasonably plain that if the AI had legal personality, it could be held liable. But that seems a rather artificial series of assumptions to make. Thank you.
예, 답변 감사드립니다.
Thank you for your answer.
중국의 후미
Now, Judge Humi from China, please go ahead.
In the primary stage, weak AI is an auxiliary tool of human being, and the user of AI should bear the tort liability. In the man-machine cooperation stage, AI and human beings may participate in the infringement jointly. Human beings can act as an agent or control manager of AI, and the manager of AI shall bear the tort liability. In the independent output stage, strong AI can be cyborg and bear the tort liability. If AI's legal person status is conferred, it is compulsory that AI has independent account so that AI can bear the tort liability independently. Thank you.
네, 답변 감사드리겠습니다.
Thank you, Judge Humi. And now, Judge Shomi's answer will be watched.
Chapter 4, Patent Infringement by AI. Common question 4. Same as a problem whether or not AI become an inventor, even if patent infringement by AI is recognized, a person or an entity should hold liability for patent infringement but AI itself. And in Japan, there are various opinions about who should hold liability among a person or an entity. One opinion to the effect that a person or an entity who transfers the products as its business that produced by AI-generated invention should be liable for patent infringement. One opinion to the effect that if a person or an entity offering an AI system as its business plays a main role to practice AI-generated invention, that person or that entity should be liable for patent infringement. One opinion to the effect that an entity who possesses AI system should be liable for patent infringement. That concludes my answers. Thank you for your attention.
네, 답변 감사합니다.
Thank you for your answer. And Judge Kim, let's listen to your answer.
학회에서는 다양한 견해들이 논의되고 있습니다. 현재 주류적인 견해는
It seems that there are various viewpoints in the academia. Currently, the predominant view is that if a natural person earns profits by using AI, that person shall be held accountable for the unlawful acts caused by AI operation. So the AI developer, user, data provider, who will be held liable among those entities is an answer that has no golden rule. The issue should be resolved by comprehensively judging who actually controls and manages the AI and who gains profits accrued from the AI. And whether AI can be held as an infringer, the majority view is that it cannot. That is the mainstream opinion. Even if AI is recognized as the main entity liable for infringement, there is little merit to hold so for now because AI has no executable property like corporations or other legal persons. Thank you. Thank you. Last but not least, Judge Mead from the UK.
Thank you very much. The answer to the first part of the question is that it would primarily be the operator of the AI, but it could in principle be anybody else sufficiently closely concerned with the operation of the AI to be a joint tortfeasor under our general law. And the answer to the second part of the question is that the AI itself could not be held liable for patent infringement because it has no legal personality and therefore isn't a recognized category of entity that could be a defendant to an action. So the answer to that is no, the AI could not be liable on the current state of our law.
예, 미드 판사님 답변 감사드립니다.
Thank you, Judge Mead, for your answer. And due to time constraints, please refer to the reference book for question 5. So that covers all of the questions we prepared for this session, and we are 10 minutes over time. But the survey that I mentioned in the beginning is now beginning, and actually, we have the answers, and this shows the statistics. So this shows the results of how participants here think about the question. The first question was, in the AI era, do you think AI can be considered as Fusita? And
그렇게 볼 수 있다고 생각하시는 분은 29%였고요.
29% agreed, while 71% of our participants said that it would be too hasty to consider AI as Fusita at the current time. And the second question that was asked in the survey was, as the Davos case addressed, there are those who believe the Patent Act should be amended to grant inventorship to AI. As some are arguing that this should be solved through legislation. So, should there be such an amendment or not? To this question, those who supported such an amendment accounted for 31% of the participants, while 69% of our participants did not agree with that idea at this moment. Thank you for your participation, and this brings us to the end of session 3. Even an AI would have had much difficulty answering the questions that were posed to our panelists, but all of them gave us excellent answers, and I would like to thank everyone who are joining us on site and virtually. Please give all the panelists a round of applause, and that will be the end of this session. Thank you.
예, 정말 흥미로운 주제였던 것 같습니다.
It was a very interesting topic. I would like to thank our moderator and all of our panelists.